So this is part two. If you go into court and they are just railroading you, you simply look at the judge and say, Your Honor, you took an oath to uphold the Constitution, and family court is designed for the best interest of the children. I am looking out for the best interest of my children. And that is it. Say that. And then if he's still going, you say, Your Honor, you took an oath to uphold the Constitution, and I would hate to have to go after your bond and put a claim on your bond. Once he realizes you know what you're talking about and he's kind of backed into a corner, things change. Again, don't be a dick about it. Just insert your rights. And at the end of the day, I mean, I'm not for fighting and trying to prove the other parent's not worthy to be a parent. The guardian ad litem will try to do that, everything else. When you deal with a guardian ad litem, there are certain things they are supposed to do. You can look that up in statute as well in your state. If they do not do it, or they're trying to pressure or push that you are a bad person, if there is no evidence to substantiate their claims, you simply say, Your Honor, there's no evidence. I've never found unfit. I am not unfit. I have been in these children's life for however many years. I don't believe 50-50 is out of the question, and I am looking out for the best interests of my children, and 50-50 would be in the best interest of them. I have been in their lives for so many years, blah, blah, blah. And you stand on that. Do not back down. That is the biggest thing with family court. Don't back down. Let them know that you know they have an oath, they have a bond. If you have to, you will go after it. You can also let them know, Your Honor, I will be appealing this decision, and we will be taking it to a higher court. No judge wants their decision overturned by a higher court because it goes on their record. Also, any claims on their bond goes on their record. If they have more than 3 claims, they no longer hold office. Here's another one. If you go and you submit forth the oath of office and the bond, if they don't have a bond or an oath of office, either one of them, they do not hold their office. They cannot try that case. Also, in April of this year, April 14th of 2023, the 5th District Court in Supreme Court has said that you have the right to have your case heard for child support in front of a federal judge. But that is only after you exhausted every other court proceeding, which means you appeal it, then you take it to appeals court, and then you take it to the Supreme Court. There's a lot out there. It's just people don't understand their rights. You insert your rights. You stand on what you believe. If you are honestly looking out for the best interest of your children, you are going to win. Again, but if you have any if you've ever been convicted of being unfit, you had CPS, you had all that stuff, it's going to be a little difficult. If you have none of that, 50-50 is what you want, and that is what is in the best